Great. I think everybody has transferred over. Good afternoon and welcome to the latest in Doughty Street's series of online seminars about the Nationality and Borders Act 2022. This seminar is about asylum processes and offences. Apologies to anybody who's expecting me to be Laura Dubinsky, QC. Laura is representing the United Nations High Commissioner for Refugees in their interventions concerning the subject of this seminar, removals to Rwanda. And so I'm afraid she can't be here this evening. Alongside me, I'm a barrister at Doughty Street Chambers. We also have my colleague Mike Spencer, who's another barrister here. Both of us are members of the immigration team. For those of you who haven't attended one of our online seminars before, your mics are muted and your videos are off. That's a pre-setting. So don't be alarmed. It just stops people accidentally interfering with the presentation. We are looking forward to your questions and comments. If you have questions for myself and Mike, then please use the Q&A function on Zoom, which you should be able to find in the options. If you have comments that you want to share with the other participants, we also welcome that. We welcome your ideas and thoughts. Please use the comment section. And we may, if we don't have time to answer use the chat section. And if we don't have time to answer your questions, we may post answers to them in the chat. We are recording this seminar and a copy, so bear that in mind, and the questions you ask and the comments you post in the chat will be recorded, and a copy will be available on the website for people who have not been able to attend. So, Ray, can we go to the first slides, please? Or the second slide. So we're going to cover three things in this webinar. It's a sandwich in which I cover points 1 and 3, and Mike covers point 2. And so I'm going to start by talking about inadmissibility and removal to safe third countries. Next slide, please, Ray. So the NABA, as I'm going to call it, or the Nationality, Asylum and Borders Act, puts on a primary legislation footing new provisions about the inadmissibility of protection claims. Next slide, please. The policy rationale that the government has announced for those is that people who have reasonably could have claimed asylum in another safe country will be inadmissible to the asylum system. Now, those of you who have been doing immigration for some time will know that at the policy level is not really a new development. The system that became known as the Dublin system has in fact been in place for something like 30 years. What is the key new development leading up to this is that almost all of the countries that were in that had return agreements with the United Kingdom were covered by the European Union's Dublin system, which the United Kingdom is no longer part of, thanks to Brexit, which has meant that the British government, while it used to at least have the option of sending people back to, in particular, France, but also Belgium, Germany, Italy, and Greece, no longer has that option. Those countries no longer accept asylum seekers back from the United Kingdom. And while that option was never used in massive numbers, it was something that gave the government at least the appearance of being able to say that people could be removed if they had claimed asylum in a safe third country. So the Conservative government has responded to that change in their abilities by introducing the policy in the second paragraph there on the page, which is to not only to send asylum seekers to the safe country of most recent embarkation, which, as I've just explained, is now almost always impossible, but to send them to alternative safe third countries, which, as I expect all of you will know, currently means Rwanda. Next slide, please. Now, the legal basis upon which that has been done up until now is the immigration rules. What the 2022 Act does is to introduce primary legislation to replace those rules. And there are three aspects that we can see in the changes that are being made. Firstly, there's a new section 80A, inserted into the 2002 Nationality, Immigration and Asylum Act, and that relates to EU nationals. There's always been a special rules for EU nationals who claim asylum. Those claims are pretty rare, at least in my understanding, but sadly we might possibly see an increase of them given the reactionary moves of Hungary towards political opponents, towards trans people, and for example Poland's increasingly misogynistic policies. But the much larger group that we're going to be looking at in practice is non-EU nationals, and under section 80b(1), they may be declared inadmissible by the Secretary of State if they have a connection to a safe third state. And I emphasize there, may. It's not a duty. The Home Office has a discretion which Parliament has not constrained or directed in any way. But what Parliament appears to have done in section 80b subsection 6 is to authorise the return of or to give its approval to the sending of asylum seekers to a state that they have no connection to, on the count of the fact that they have a connection to another state, to another safe third country. And that is a almost entirely new policy by the United Kingdom government. It has been used once in the past in the case of al-Masari, where the United Kingdom created a bespoke agreement with the Dominican Republic to send the Saudi Arabian dissident, Mr. al-Masari, there. And when that was challenged on an appeal to the tribunal, which was then available, the Home Office lost. The judge decided that Dominican Republic wasn't safe enough. And has been talked about in the past, most notably perhaps by Tony Blair, who talked about sending African asylum seekers to Ukraine. Next slide, please. So drilling down then into the test for the application of these inadmissibility provisions, the EU claims there's a list of examples of when there might be exceptional circumstances that allow for the claim not to be certified. One of those is, for example, where the country is derogating from the European Convention on Human Rights. And more importantly for our purposes today, a safe third country or safe third state is defined as one where the claimants, essentially their protected rights won't be threatened in a way that would constitute an asylum claim or a breach of Article 3, and that they must not only be protected against refoulement in that state, but they must be able to apply for recognition as a refugee and receive protection in accordance with the Refugee Convention. Now, one might think that, certainly from the government's point of view, that rule will generally apply to EU states. Next slide, please. So what's more important for an individual claimant may be whether or not they personally have a connection to the third state. Now, this is important, including for the Rwandan countries, because a person who doesn't have a statutory connection to to a third state can't be sent on to a country like Rwanda. So looking then at those, the 1 and 2 under the statute, section 80C, are that the person has been recognised as a refugee or granted equivalent protection. The second is that they have claimed refugee status or equivalent protection, and that's, the third is that they've claimed refugee status or equivalent protection, and that claim is pending or has been refused. And those cases should be factually fairly clear, because there will be documentary evidence about whether or not the person has been recognised or whether or not they've been made an asylum claim. The more problematic but more common categories will be 4 and 5. So 4 is that the person was present in the state, eligible at that time to claim asylum or equivalent protection, and it would have been reasonable to expect them to make the claim, but they failed to do so. And then there's a provision for people who haven't been in that third state, where it simply would have been reasonable to expect them to make a claim for asylum or equivalent protection there instead of in the UK. The statute doesn't tell us what is meant by reasonable to expect, or how to approach that phrase. And there's an indication in the explanatory note of the Home Office's position in terms of the category 5. The Home Office say, as an example in the explanatory note, that it could be where the person has close family members. And then they say there was nothing preventing them making a claim there. And I think that's characteristic of the way that the Home Office use these kinds of words. Obviously, if something prevented them from making a claim there, they couldn't have made a claim at all. Didn't get near reasonableness. As I think in this very political space, there's often a kind of shading between prevent, reasonable, and other formulations, depending on who the Home Office are talking to, and here they were talking to Parliament. Next slide, please, Ray. So what are the legal issues and practical issues that we might expect to arise for reasonable to expect? Well, we've already seen, those of us who've been working on the Rwandan cases, have seen that the Home Office screening interview that they're using to assess whether or not someone is inadmissible isn't really being used to tease out the facts that a decision maker would need to have to decide whether it was reasonable to expect somebody to claim asylum. People, in one case that I was involved with, the claimant didn't know what countries he'd been through. Nobody mentioned France at the interview. He didn't. The interviewer didn't. The interviewer didn't ask whether he'd seen any officials in France, whether he knew that he could claim asylum in France, whether he knew he was in France. Didn't ask whether he was frightened of the smugglers who were armed, about what would happen if he tried to run away from the smugglers, tried to get to an official to claim asylum. None of that was explored. I think for us as lawyers, a really useful case is the case of Q against the Secretary of State. That concerned Section 55 law that had just come in then, under which asylum seekers were denied asylum support if they had not claimed asylum on arrival, or if they'd not claimed asylum as soon as reasonably practicable. And the Court of Appeal approved a really detailed inquiry into the Home Office's procedures. And out of that, I've suggested 5 points, but there will be more that we can look at to check that the Home Office is treating asylum seekers fairly. Now, the first of those was, are asylum seekers being told about the purpose of the screening interview? Are they being told at the beginning of the interview that what's really important for them is that they communicate why they didn't claim asylum in the countries that they passed through? Are they being told that this is their opportunity to explain why they don't think they'd be safe if they were sent to Rwanda or to some other country that they haven't been in? We haven't seen any clear instructions to staff about what the Home Office's position is on that phrase, reasonable to expect. Does it mean that the person had to know that they had the possibility of claiming asylum? Did it mean that they had to believe that they were safe, that it was safe for them to claim asylum, that they wouldn't be harmed, for example, by the smugglers? There aren't any clear instructions to the staff about trying to work out and take into account what the claimant's point of view was. We haven't yet seen clarity about whether here in this statute, obviously it's only just come into force, reasonable to expect means reasonable for that asylum seeker with their knowledge and understanding of the situation to claim asylum, or is it some objective test? It seems to me that that would be extraordinarily harsh to treat people differently because somebody else would have claimed asylum, but not them because they were scared or because they didn't understand. The fourth point that was an important one in Q was, is the applicant being given the chance to rebut any suggestions that they're lying? And that may be important where people are told that actually you did know you were in France, or we don't believe that you were only in France for 24 hours. We don't believe that you were kept in the back of the lorry until you got out at the beach, for example. And then the last one I've already mentioned is, are claimants being given enough information and a proper opportunity to comment on the safety of Rwanda for them? Are they being told about the arrangements between the United Kingdom and Rwanda where these might be relevant to their particular safety? So, for example, if a claimant is from a country that has political ties to Rwanda, then it may be relevant to know to what extent there are guarantees and to what extent those guarantees are meaningful. But it may also be important for the applicant to have an opportunity to gather information about their country's ties to Rwanda and present that to the Home Office, because one can't really expect asylum seekers arriving here to be ready to make a presentation about their own country's political ties to various different places in the world. Next slide, please. Right. There are some other issues, lots of issues, and putting aside the Rwanda question, as we've seen, the Home Office has a discretion about whether or not to treat the claim as inadmissible. And that opens up a whole set of issues. First of all, is the apparent policy to presumptively send people to Rwanda? Is that rational? When Theresa May asked Priti Patel in the House of Commons what her criteria were, her policy, she said it was a secret. Is that lawful? If I don't know what the criteria are, how can I make sure that the Home Office know the material that's relevant to the exercise of the judgment based on those criteria? If the Home Office policy, as it seems to be, is limited to people who arrived by certain means, is that a penalty against asylum seekers connected to the way in which their illegal entry or presence in the United Kingdom, and therefore a breach of Article 31(1)? Is the Home Office unlawfully discriminating either directly by lists or indirectly by the way their policies are operating on the grounds of nationality, which is prohibited under the Refugee Convention, or on other grounds? And just to be clear here, even though the Refugee Convention isn't part of the municipal law of the United Kingdom in the way that the European Convention on Human Rights is, the courts may be able to interfere with the exercise of a discretion where it's based on a misunderstanding of international law. So, for example, if the Home Office think that they're not breaking the Refugee Convention by discriminating on nationality grounds, but the courts decide that in fact they are, that might be a ground upon which the courts could require the Home Office to change their policy, or at least to revisit their policy, and to re-exercise their discretion. Maybe that the Home Office can openly breach the Geneva Convention, but they would have to do so explicitly, telling the courts that they understood that they were doing that and bearing the political cost of it. What about the policy and approach and evidence gathering towards people who are, at the moment that they're threatened with removal, in an especially vulnerable position? Very many of these people will be traumatized. They'll have been scared witless by the smugglers who they employed to get them to a safe country, but who are obviously concerned with maintaining their own business and don't stop at terrifying people. And then other particular groups, for example, children, is another group where we would want to see what the Home Office's policy and approach is. And then the last of those issues about the discretion, suppose there's been a long time delay before the decision is taken, or suppose the person has been here while the Home Office think about removing them under inadmissibility rules. It does seem that the inadmissibility policy is partly being used as a strategy to punish asylum seekers by delaying decisions on their asylum claims, even where the Home Office can't remove them. And that may be something that requires, or that taints the actions in those individual cases with unlawfulness. And then lastly, of course, there's all the stuff that's going on in the courts at the moment about Rwanda as a particular destination. Has the Home Office rationally investigated it? Is the Home Office rationally relying upon assurances? What's the significance of the failed scheme that operated with Israel? What's the significance of reports about human rights abuses in Rwanda, sometimes directed against refugees? So those issues may well arise in judicial review proceedings. Whether they're resolved by the time your clients are in the High Court, I don't know. But that may go on being new evidence or new material coming out about it. Next slide, please, Ray. I think that wraps up my presentation about the inadmissibility criteria. Squeezing a lot in, 3 areas into 1 hour. So that's been a bit of a race. Please do raise any questions that you have about that in the Q&A, and I will now hand over to Mike Spencer, who's going to talk about accommodation centres.
Hello, everyone. Yes, I'm going to discuss the provisions in the Nationality and Borders Act that concern asylum support and particularly accommodation centres. Now, for the first slide, I've chosen a picture there of the Napier Barracks because I think it nicely illustrates 2 points in relation to the policy on accommodation centres. Firstly, they're not a new policy. Accommodation centres have been around, certainly in the heads of policymakers, since at least 2002. And as we'll see, there are numerous existing provisions, many of which haven't yet been brought into force, that facilitate the establishment of accommodation centres. And secondly, I think it nicely illustrates how easy it is for an accommodation centre to take on many of the features of a detention centre. And then we start to get to the question, well, if it looks and feels like a detention centre, is it a detention centre? And more seriously, we look, what we're seeing is a shift away potentially from using asylum support powers to provide for the minimum subsistent needs of asylum seekers, albeit within the context of a hostile environment, which is supposed to encourage people to leave the UK, towards using asylum support accommodation to facilitate removal. And that may well be problematic and raises all sorts of legal, practical and moral issues, as we'll try to see in this very short presentation. Next slide, please. Now, there's a lot we don't know about the policy, but we do have this one sentence from the new plan for immigration. And there's quite a lot we can read into it. So first of all, we see that the purpose of the accommodation centres is to help speed up processing of claims and the removal of people who do not have a legitimate need to claim asylum. So we can see that we're moving away from that theme that I'm talking about, where we're moving away from asylum support to provide for minimum subsistence needs and towards asylum support as a way of facilitating removal in tandem, potentially with detention as such. And secondly, we have this phrase, people who do not have a legitimate need to claim asylum. Now that's quite carefully worded, and it seems to me the reason that's carefully worded is to capture those who are subject to inadmissibility decisions, and particularly those who have a connection with a safe third country and may be removed to another safe third country. And as we'll see, that what the Act does is it allows the inadmissibility process, or it clarifies how the admissibility process will work in the context of asylum support decisions. And finally, we see that we're talking there about the provision of very basic accommodation, and we'll look at perhaps some of the standards we might expect from an accommodation centre. And again, coming back to this purpose of processing asylum claims, presumably as quickly as possible to facilitate removal. Next slide, please. As I mentioned, there's quite a lot already on the statute book. So of course, there are existing powers to provide accommodation to asylum seekers under Section 95 of the 1999 Act and failed asylum seekers under Section 4 of the 1999 Act. And there's nothing in theory that would prevent the Home Office from accommodating asylum seekers all in the same place, in the form of an accommodation centre. And that's precisely what we saw with the Napier Barracks in Penally, and also with many of the hotels looking at interim accommodation during the COVID pandemic. However, that did lead to legal challenges, and there were issues with the lawfulness of that, which is why the Home Office may choose to bring into force existing powers. Most principally, Part 2 of the 2002 Act, which provides for if it is ever brought into force, quite a detailed scheme for accommodation centres, and we'll look at that in a moment. And also there are various reforms in the 2016 Act which still haven't yet been brought into force, and those in particular abolish Section 4 support for failed asylum seekers, create a new form of support called Section 95A support, and make various other changes, particularly in relation to appeal rights. But as I said, there's a lot we don't know, and there's a lot that appears to be going on in the background in terms of policy discussions, which obviously I'm not party to. Next slide, please. Let's then look at the changes introduced in the 2022 Act, the Nationality and Borders Act. Those are quite limited, but we can read a lot into them, potentially. So what Section 13 does is it allows the Secretary of State to house asylum seekers in different forms of accommodation, depending on what stage their asylum claim is reached, and particularly depending on whether their claim is being considered for a declaration of inadmissibility. Now, again, you might say that power is redundant because there's nothing to prevent the Secretary of State from accommodating asylum seekers in different places or in different forms of accommodation. The core duty is simply to provide adequate accommodation. But it goes to purpose because what we're seeing is potentially the Secretary of State intending to use particular forms of accommodation for particular groups where removal may be facilitated within a shorter period of time. And this Section 13 would allow that potentially because it would allow a discrimination based on where somebody is in their asylum claim or where they've reached in the procedure. And what Section 17 does is it clarifies, it's actually headed as a clarification of the law rather than as a change in the law. It clarifies that an inadmissibility decision acts as a refusal for asylum support purposes. So if your inadmissibility claim, if your claim is being considered for inadmissibility, then you're an asylum seeker for support purposes because your claim hasn't been determined. But if you've had negative inadmissibility decision, then you're a refused asylum seeker for support purposes, and you move on to Section 4 support or potentially no support at all. And I think what we can read from that is that the intention, potentially, and again, I may be reading too much between the lines, is that accommodation centres will be a way in which the Secretary of State can facilitate removal to Rwanda or any other safe third country of people who are arriving by boat or otherwise. And so the idea would be that to hold them in detention as long as possible, but if they're released from bail from detention, rather than releasing them into the community, they can be released to an accommodation centre where it'll be more easy to keep tabs on them and potentially remove them within a shorter period of time. Next slide, please. Next clue we have as to the Home Office intentions is a tender that was released in 2022, looking for up to 8,000 service users for provision for up to 8,000 service users in national accommodation centres who'll be accommodated for periods of up to 6 months. And pausing here, another interesting issue in relation to accommodation centres comes down to, as we saw with the Napier Barracks, private provision, because a lot of this work will be contracted out to third-party providers, and then questions arise, particularly where we blur the line between providing support and detaining, as to who is responsible, tortiously responsible for claims for unlawful detention or claims for negligence. Next slide, please. Another clue is we have a fact sheet published by the Home Office in relation to a proposed accommodation centre in Linton on Ouse in Yorkshire. And the fact sheet is very much addressed towards local residents to reassure them that the proposed accommodation centre will not have too much of an impact on their community. But it tells us perhaps what the intention is in relation to the features of the accommodation centre, so that we can see that initially it would only be used for destitute single male adult asylum seekers, so no children or families. That the intention would be to design a site that is as self-sufficient as possible, so that asylum seekers won't be relying on local communities. There won't be a curfew as such, so residents would be expected to return by 11 o'clock, and if they don't, they'll get a polite phone call reminding them that they're expected home. There'll be on-site recreational and cultural activities, so again, no reason for residents to want to leave the accommodation centre, and all medical services will be provided on site. Now, in relation to curfews, what we saw in the COVID pandemic is it's quite easy for a de facto curfew to arise, particularly where you have contraction and subcontraction of functions. So in the hotels, for example, in January 2021, notices were issued by accommodation providers informing residents that they could only leave the accommodation for 1 hour at a time. And I know there's a host of claims in relation to that as to who's responsible for that, whether that constitutes an unlawful detention or an unlawful imprisonment at common law or under Article 5, and who's responsible for that. Next slide, please. So we can see that, as I say, what we gather from that is that likely we'll be looking at accommodation centres used as an add-on to detention, or in tandem with detention, or an alternative to detention, to facilitate removals, most likely of claims that are either being considered for inadmissibility or have been declared inadmissible. And that raises a whole host of potential legal issues, which I've summarised in this slide here. So the first question is, well, what happens if you get your inadmissibility decision and removal is not feasible to Rwanda within a reasonable period of time? Technically, applying the provisions as amended in the Nationality and Borders Act, you're a failed asylum seeker, your claim has been determined, and you're not eligible for asylum support. Are you eligible for Section 4 support? Is it, and the criterion there, is support necessary to avoid a breach of your human rights, bearing in mind that you can't voluntarily return to your home country, or you can't be expected to, and there doesn't appear to be much in the way of provision for voluntary return to Rwanda. It may be that the tribunal or the courts find that in those circumstances, that support is necessary to avoid a breach of human rights. But again, a lot will depend on the detail there. Will there be a right of appeal to the Asylum Support Appeal Tribunal? Well, Section 17 of the 2002 Act, which is not in force, would remove the right of appeal where the decision is to accommodate someone in an accommodation centre. So we'll have to see whether that comes into force and whether that's the intention, in which case the only remedy will be judicial review. What about those where the stay extends beyond 6 months? Section 25 of the 2002 Act allows for that, where the Secretary of State considers it to be necessary. But then, and that sort of feeds into the next point, which is about curfew powers. There are curfew powers in the 2002 Act. We've seen that the intention is not necessarily for them to be used or brought into force. But if they are, then JALA establishes that a curfew can constitute an imprisonment at common law and a deprivation of liberty under Article 5. And then that creates all sorts of interesting questions, particularly when we look at what relevance do we have are the Hardyal Singh principles in that context. What is a reasonable, is there a duty only to accommodate an accommodation centre for a reasonable period of time? And what is a reasonable period of time in that context? And you may then see judicial reviews aimed at releasing somebody from an accommodation centre. Perhaps release isn't the right word, but seeking accommodation elsewhere in the community. What will be the Home Secretary's policy in relation to vulnerable residents, particularly victims of trafficking and those who require mental health treatment? Will there be carve-outs for those so that they won't be accommodated in accommodation centres? Or will the Secretary of State say that provision can be provided, that support can be provided on site? What about children? Well, we've seen that the policy intention at the moment is not to house children, certainly not at Linton on Ouse. But Section 36 of the 2002 Act, again not in force, would rather concerningly provide that children are not to be considered as part of a local education authority if they're housed in an accommodation centre, which would suggest that there's an intention to provide education entirely on site. And that, again, may raise all sorts of issues. I've mentioned the Napier Barracks case, NB, and one of the issues in that case was Mr. Justice Linton found the fact that the accommodation is similar to detention and feels like detention or has many of the attributes of detention is relevant when considering whether the accommodation is adequate for the purposes of the 1999 Act. And so if you're looking at people who are accommodated for a long time in an accommodation centre in substandard conditions, then it may be that the successful challenge can be on the basis that the accommodation is inadequate, which rather feeds into what I was saying about the sort of quasi-detention situation. What if the residents have family elsewhere in the UK? Will there be exceptions for them? If those exceptions aren't considered or applied, will that constitute interference with Article 8 rights? What about where you have mixed households, potentially, those with partners who are settled in the UK? That may be a rare instance, given the cohort that this is aimed at, but it may not be. And finally, what about access to legal advice? And are there any, and the implications for Article 6 ECHR? And that's legal advice in two respects. Firstly, in relation to challenging the inadmissibility decision and pursuing your asylum claim, but also in relation to challenging your conditions of the accommodation or potentially the fact of being accommodated in an accommodation centre. And we don't have much in the way of detail as to how legal aid provision is going to be facilitated there. So a lot of legal issues potentially leading to a lot of challenges, but a lot dependent on how the policy is going to be implemented in practice. And I'll say by way of aside that Hambledon District Council have already sent a pre-action letter to the Home Office objecting to the proposal to accommodate asylum seekers at Linton on Ouse. So there's a side issue there as to whether local authorities are going to be resisting the establishment of accommodation centres in their areas. And now passing back to Simon to talk about offences.
Thanks very much, Mike. So I will just talk about offences, and then there are a couple of questions in the Q&A, which I'll try to come to. So could you bring up the next slide, please, Ray? So the government is making amendments to the criminal law to expand the list of offences that can be committed under the Immigration Act, and to impose or to allow for the imposition of harsher sentences, prison sentences, breaches of those provisions. And the rationale there is to include seeking to enter the UK illegally as an offence, and to strengthen existing facilitation offences, to take tougher actions against those who pilot small boats, which includes, of course, many refugees who are forced at gunpoint to pilot the small boat by the smugglers who they've engaged to get into the UK. Next slide, please. I'm going to look at three key changes. There are more than that. The first of those is the new offence of arriving without entry clearance. The second is the amended offence of facilitating arrival, and the third is longer sentences. And these provisions come into force tomorrow. Next slide, please, Ray. Thank you. So there's a new offence, section 40 of NABA amends section 24, restructures it, but the key new offence is listed in what will be section 24, or what section 24 D1. And as you can see there on the screen, that has two conditions. The first is that it's a person who requires entry clearance under the immigration rules. And the second is they knowingly arrive in the United Kingdom without a valid entry clearance. And that situation, it's an offence. And as we shall see, it's an offence for which a person could be sentenced to up to 4 years in prison. Next slide, please. But does it work? So what does requires entry clearance under the immigration rules mean? Paragraph 24 of the immigration rules, if you only read paragraph 24, you'd think that everybody needed an entry clearance, unless they were a non-visa national coming for less than 6 months. Because paragraph 24 says that visa nationals and anyone seeking entry for more than 6 months must produce to the immigration officer an entry clearance. But that's obviously not true. It's not a complete code. We can see that, for example, in paragraph 18, which provides that returning residents don't need to produce an entry clearance, as you might think. But also, and importantly for our purposes, we can see in paragraphs 330 and 339E of the immigration rules that where the Home Office decides to grant asylum or humanitarian protection, the immigration officer will grant leave to enter without there being an entry clearance. So can it truly be said that an asylum seeker is a person who requires entry clearance under the immigration rules? Well, not to be granted leave to enter, they don't. Not to be granted leave to enter as a refugee or with humanitarian protection, they don't. So what else would it mean to say that a person requires an entry clearance for, if not to obtain leave to enter? So I think there may be a good argument here that that provision just doesn't bite on asylum seekers, and so bites on the very limited class of people who turn up without an entry clearance and say, I want to be admitted for some purpose other than asylum. And even then, if the Home Office amended the immigration rules, or when we look at the interpretation of the immigration rules, we should remember that under Section 2 of the 1993 Immigration Act, immigration rules mustn't lay down any practice contrary to the Geneva Convention. As the rules obviously recognise, asylum seekers can be given asylum, can be given leave to enter, even if they didn't get a visa before they came as an asylum seeker. They recognise that, of course, because you can't get a visa as an asylum seeker. So this does strike me as a provision that's intended for the consumption, perhaps of ministers, perhaps rather gullible ministers, or politicians who can now announce that everybody needs an entry clearance. Whether we will actually see prosecutions of asylum seekers, I don't know. We did see prosecutions of asylum seekers for illegal entry by the Home Office and by prosecutors who didn't understand that under the Immigration Act, a person doesn't enter the United Kingdom when they cross into the maritime waters of the UK, and they can't enter the United Kingdom in a boat. They have to disembark from the boat under Section 11. And obviously, the people who are arriving in the small boats only get out of the boat once they're already under the control of immigration officers and people who are working with immigration officers. So it's very hard to see how any of those people could also be illegal entrants in the wider sense. But no doubt we will see the government at least trying to use some of these provisions more harshly. Next slide, please. And one of the other key legal change that's being made is that the government is getting rid of the foregain requirement for facilitating the arrival in the United Kingdom of individuals who are believed to be asylum seekers. And that's particularly important for lawyers, because up until now, the language of this section has meant that a lawyer who acts pro bono for an individual knew that they couldn't be committing this offence if they were advising or assisting somebody who was outside the United Kingdom as to their rights and remedies in terms of trying to travel to the United Kingdom. But now the only explicit statutory exception is under subsection 3, and that applies to persons acting on behalf of an organisation which aims to assist asylum seekers and does not charge for its services. Now, it's unclear to me whether that can be relied upon by people working for solicitors firms who at least charge some people for their services, or for individual sole practitioners who at least charge some people for their services, even though they are working for that person and advising them pro bono. And in this, it's not clear to me how the section is intended to operate for people, for example, advising people on seeking, for example, we might be advising Afghan or Ukrainians outside the United Kingdom on applying for visas to come to the United Kingdom, and to what extent that is exempt from the section, because if one looks at the section, it's not clear that the section has an exemption for those activities. Next slide, please. The Act increases the maximum sentences very substantially, which will have a knock-on effect to the approach of sentencing of the courts. So illegal entry and similar offences, which includes the one I've just described, are generally become 4 years instead of 6 months. Entering in breach of a deportation order, however, becomes 5 years, and facilitating entry, which would include people piloting boats, now carries a maximum sentence of life, and magistrates can impose sentences of up to 12 months. And you'll see what the ministers require or see as aggravating factors: that people cause danger, that they disrupted other people's services, or as we can see, where there are criminals who've previously been deported from the UK. Of course, you don't need to be a criminal to be subject to a deportation order, but most people who are subject to deportation orders have committed criminal offences. Or persons who've been repeatedly removed as failed asylum seekers, presumably who aren't hurting anybody else, but are simply trying to get what they see as to a safe haven. Next slide, please, Ray. Now, some of the issues that we might see in the courts. First of all, there is a statutory defence under Section 31 of the 1999 Immigration Act, based on Article 31(1) of the Geneva Convention, not to penalise refugees for their illegal entry or presence. That has a list of statutory offences that it applies to. It doesn't apply to the offences under Section 24 and 25 of the Immigration Act 71. There is a much broader defence for victims of trafficking, but in any event, the courts have held that these statutory exemptions don't exhaust the court's power to stay a prosecution for abuse of process. And I've given you the cases there, ASFOR and the very recent case of AAD, in which the courts held that these two provisions respectively don't do that. So where people are victims of trafficking or refugees, it would seem that if properly represented, that they should be able to prevent the successful prosecution where that would amount to a penalty for their illegal entry or presence. That may be harder to argue for people who are being prosecuted for bringing other people to the UK. But we also may see challenges to the prosecution policy, given in particular the unhappy relationship between the Crown Prosecution Service and police on the one hand, and the Home Office on the other, who certainly at some points last year, the Home Office seemed to forget that the Crown Prosecution Service is independent of politicians like the Home Secretary, and began publicly bullying the Crown Prosecution Service for not bringing prosecutions when they thought they should be brought at the Home Office. Next slide, please. So that's the end of the presentation, and I just want to try and turn to the questions and answers that have come up. Taking the second one from anonymous attendee, this is a reference to the, or I think it's raised because one of the provisions of the Act that we haven't talked about, the 2022 Act, yes, and Ray's reminding me, I forgot to say that there is a webinar feedback form, which we'd very much like you to complete. Section 8 of the 2004 Act is being amended, not yet, but is going to be amended, or could be amended once it's brought into force, by Section 19 of the 2022 Act. Section 8 has in some respects similar provision to the one that I just talked about with changing the law on arrivals, was one that appeared to be harsh, but in fact didn't make any real difference. Section 8 required decision makers and judges to take into account a whole list of things that politicians thought were bad when deciding the credibility of an asylum seeker. And that led to the decision of the Asylum and Immigration Tribunal in SM 2005 UK AIT 116, that Section 8 didn't mean that this was the starting point for an assessment of credibility, and that essentially, if a judge thought someone was telling the truth, having heard their evidence and taken into account the fact that they may have used false documents or not claimed asylum on arrival, that the judge was expected to treat them as telling the truth, because that's the judge's job. So here we are 18 years later, and the new Act is going to require procedure rules that tell judges that they have to include in their reasons that they've done this. We will have to wait and see, I think, whether that actually makes a difference to how judges decide cases. I think there are a problem with some of our immigration judges who are too skeptical, but they don't, in practice, need the statutes to be too skeptical, and the statutes haven't, at least in my view, changed the approach of judges to asylum seekers. We'll see. Mike, did you have any thoughts on the first question and answer? It's in there. You're muted. I have some.
Go ahead, Simon. I think that's one more for you.
All right. Yeah. So Diana Bercucci has asked a broad question about whether or not what legal bases we can have to challenge sending people to Rwanda. And the answer to your first question there, Diana, is that I mean, asylum seekers are indeed relying on the fact that they've suffered torture in their claims to challenge removal. They're relying on it to say that the Home Office hasn't exercised their discretion properly when treating their cases as inadmissible. And I think the second question you asked there is one that will be examined by the High Court in detail, and probably by the Court of Appeal, and by the looks of it, the Strasbourg Court under the European Convention on Human Rights, to see whether or not the Home Office have eliminated any real risk of that happening. The courts have not expected decision makers to guarantee that bad things won't happen, but to at least make sure that there is not a reasonable degree of likelihood of a real risk of being exposed to torture. Are there any other questions, things that people wanted to say in the chat? Please feel free to do that. If anybody has any more questions they want to raise. And Mike, do you know what's the next seminar?
I think the next seminar is on age assessment, but just have to check that.
I apologise for everybody. I should have got that in my notes before I started talking.
We've had one on the trafficking provisions in the Act, which was last week. I think the recording is available if you email to request. There should also be...
We have age assessment coming up, if you look at the website, on Wednesday, the 6th of July. And then we have appeals and removals on Thursday, the 14th of July. And Ray Monda, my colleague, has very helpfully posted a link in the chat to that webpage, which is where you can go to find out when the next seminar will be. I mean, I think that some of these issues, I think in particular, inadmissibility is going to be shaped by what the courts are saying in the coming weeks and months. We don't currently have a date for the second flight to Rwanda, but it's quite possible that will be done soon. Government seems to want to be showing at least their supporters that that's what they're doing. As for the rest, I think, I mean, my view of the Act is it's a mix of some very problematic provisions that the government is quite serious about, and other provisions that may prove to be more propagandist. And sorry, someone's posted a comment in the chat. We do indeed, you're quite right, have one on asylum determination and treatment of refugees on the 4th of July. Thank you very much, Suzanne, for looking at the website for posting that. Sorry, there's a long list of seminars on this, and I wasn't properly prepared to talk about them all at the end. Anyway, I think that brings to an end what we want to talk about at this seminar. Very much hope that we'll see those of you who are interested at the next one, which is on Monday the 4th at the same time at 5 o'clock, and is bookable through the same system, where my colleagues Michelle North, Marisa Cohen and Zoe Harper, all of whom specialise in dealing with asylum claims and trafficking claims, will be talking about the process of asylum determination, and where they will be covering things like the section that we just talked about on credibility in more detail. So thank you all very much for coming, and I hope you have a nice evening. Bye-bye.
Thank you.